mapambano, bado mapambano, Wakenya msilale, lale lale, Wakenya msilale, bado mapambano, 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 bado mapambano, mapambano, mapambano.
Ilikuwa ni recording. Turudishe nyuma. Acha hivi.
By some of the petitioners that the speaker's mere participation in the proceedings or involvement in political arguments is sufficient to establish constitutional bias.
Very biased.
The constitutional decision makers under Article 145 and Article 150 are members of Parliament and senators collectively acting through the respective houses of Parliament. We therefore find that the allegations of whether an impeachment should succeed or fail. We are accordingly not satisfied with the broad proposition advanced by some of the petitioners that the Speaker's mere participation in the procedure prescribed in the Rai, Rawal and Tunoi decisions.
The other main issue relates to public participation.
Interest advanced by the petitioners against the Speaker's members of Parliament and senators are, on the material before this court, no more than bare and uncertain.
Participation in the impeachment process was constitutionally deficient, conducted by the National Assembly, met the constitutional threshold required under Articles 10 and 118 of the Constitution. Second, whether the Senate, upon receipt of the impeachment motion, was itself obligated to carry out a public. That many venues were inaccessible, changed without notice, or restricted to party members. They also pointed to defiance of conservative used process null and void. Their challenge was mounted at the 3 levels, and the petitioner advanced. They attacked the National Assembly's public participation, judicial, and therefore attracted an independent obligation to facilitate public participation. They argued that this obligation could not be discharged vicariously through the National Assembly, and that by proceeding without its own engagement, the Senate compounded the defects of their standards. With respect to the Senate, they contended that Senate conducted no public participation. Public participation is not merely a procedural formality, but a foundational constitutional value, one deeply woven into the democratic fabric of this nation. It is an expression of the sovereign will of the people, who, by virtue of Article 1, Sub-Article 1 of the Constitution, are the ultimate repository of all sovereign power. That sovereignty, though delegated to state organs under Article 1.3, is not thereby surrendered. It is retained by the people and continuously exercised through, amongst other mechanisms, active and meaningful participation in the process of governance. Public participation is therefore not a gift of the state to the citizens, but a constitutional right that the state is obligated to facilitate, to protect and to give full effect to. Under Article 10.2a of the Constitution, public participation is expressly enumerated as one of the national values and principles of governance. Article 10.1 makes clear that the national values and principles of governance bind all persons, state organs, state officers, and public officers whenever they make or implement public policy decisions, apply or interpret the Constitution or any law. The imperative of public participation finds further and specific expression in the context of Parliament in Article 118 of the Constitution, which reads as follows: Parliament shall A. Conduct its business in an open manner, and its sittings and those of its committees shall be open to the public, and B. Facilitate public participation and involvement in the legislative and other business of Parliament and its committees. At its core, public participation refers to an active process of interaction and engagement among various stakeholders who have an interest in or are affected by a particular decision or course of action. The word active is of constitutional significance. It signals that the Constitution does not contemplate a passive, cosmetic, or performative exercise in which the exercise is merely notified of a decision, in which the public is merely notified of a decision already made. It demands instead a genuine and substantive process which the people are afforded a real and meaningful opportunity to shape the decisions that affect their lives. In essence, public participation is the mechanism through which
Try new Nivea Derma Control.
they challenged the approval of H.E. Kindiki as Deputy President and argued that no public participation preceded the vote, yet the formulation, review, or consideration of policy or law. We respectively associate ourselves with and adopt as correct the position taken by this court in Mwangaza versus County Assembly of Meru that public participation in impeachment proceedings primarily occurs at the County Assembly level rather than at the Senate level, since the County Assembly is the initiating body that formulates and debates impeachment before transmitting it to the Senate for At the Senate stage, the function being discharged. Additionally, it promotes a participatory approach to governance, with Article 10.2a identifying democracy and participation. 1. It is not acting as a conduit for public opinion, but exercising delegated sovereign authority on behalf of the people. The Constitution to be concluded in not more than 10 days pursuant to Article 145. His Excellency Gachagua had not completed his. It was at that
645 nilikuwa natakana hiyo 350 destination.
that conclusion is firmly supported as a sitting day to conclude procedural matter. The motion, if carried, will resolve the Speaker Gazette back to the Senate and is accordingly to the Senate to determine and miscarriage of justice. In job, Banda as the State Court International Services Limited, because of the Constitution, impact on a citizen.
Under Article 47 and Article 50, we find that His Excellency Gachagua's rights were infringed when the Senate declined to allow an adjournment. Feeling of we now is the conundrum, and where that conundrum deliberately and unequivocally withholds authority from the court, such limitation must be respected. aspect of remedies. Before pronouncing our final orders, we deem it necessary to first address the nature of remedies sought and to explain their constitutional foundation. This court has been invited to grant various enforcement of rights and fundamental freedoms. These remedies include declarations of rights, injunctions, conservatory orders, Article 145, sub-article 7 of the Constitution provides for the court. If at least 2/3 of all the members of the Senate in this present case, and against this background, and having found that the rights of His Excellency Gachagua
Wakenya msilale, lale lale, Wakenya msilale, bado mapambano, 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 bado mapambano, 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 bado mapambano, Wakenya msilale, lale lale, Wakenya msilale, bado mapambano, 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 bado mapambano, 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 bado mapambano, Wakenya msilale, lale lale, Wakenya msilale, bado mapambano, 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 bado mapambano, 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 bado mapambano, Wakenya msilale, lale lale, Wakenya msilale, bado mapambano, 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 bado mapambano, 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 bado mapambano, Wakenya msilale, lale lale, Wakenya msilale, bado mapambano, 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 bado mapambano, 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 bado mapambano. Harambee! Wanta! Harambee! Wanta! Tunawanyoka na haya yake. Tunawanyoka na haya yake. Harambee! Wanta! Harambee! Wanta! Kuza ligiji! Kuza stima! Kuza ligiji! Kuza stima! Kuza ligiji! Kuza stima! Kuza ligiji! Kuza stima! Tunawanyoka na haya yake. Tunawanyoka na haya yake.
His Excellency Gachagua is hereby declined. 2. A declaratory order is hereby issued that His Excellency Gachagua's fair trial rights were infringed when the Senate declined to allow an adjournment in the
Kama ilikuwa violated kweli, Gachagua's rights were violated. Alafu tena unasikia kwamba impeachment has been upheld.
These people, these are Kasongo's people. Hii watu walikula kitambo, lakini aluta continue.
Aluta continue. Aluta continue.
Bado ni one time. We will not be intimidated.
Yes.
We will not allow this.
Yes.
This is a new Kenya.
Yes.
We shall continue. And we will make sure one term is reality.
Very good.
One term is
reality.
One term is
reality.
We will not be cowed by this judgment.
Yes.
Never will we be cowed. We will not allow.
Yes.
Hawa ni jakari wa Katongo. Vibaraka Kasongo ndiawa.
Bure kabisa.
Vibaraka